Please be seated. The sitting is open. The court meets this morning to resume hearing the first round of oral argument of Myanmar. I now give the floor to Professor Stefan Thalmann. You have the floor, sir.
Mr. President, Madam Vice President, distinguished members of the court, good morning. My task this morning is to address the Gambia's argument on what it refers to as Myanmar's anti-Rohingya hate speech and propaganda. This presentation builds and expands on Chapter 11 of Myanmar's written pleadings. Before addressing the Gambia's substantive argument, let me say that some of the statements we heard last week were truly abhorrent and the distortions of history disconcerting. This presentation is in no way trying to defend statements inciting discrimination or violence, let alone genocidal violence. But let me remind you, however, that what you have heard so far is only the Gambia's presentation and interpretation of these statements. In many cases, the Gambia's exposition does not reflect reality. Let me just give you one example. One of the Gambia's arguments is that the utterances of Myanmar soldiers are an indicator of genocidal intent. Mr. President, members of the court, last week you were presented on screen with 7 statements which allegedly represented utterances of soldiers posted online. However, the Reuters report that is adduced as evidence does not even mention the word soldier. All statements are unattributed. One of the 7 statements is not even included in the report. One of the statements was a comment on a news article on attacks on police stations by Bengali militants. There are many more such examples, and I would refer you to Myanmar's written pleadings. This example is only to show that when the court deals with the statements put forward by the Gambia, it needs to focus very closely on the original statements themselves. The court should take note of the fact that in many cases, the Gambia does not put forward the statement itself, but relies on secondary sources, reports, and news articles. As explained by Ms. Cordone last week, material of this nature is of no evidential value. Myanmar trusts that the court, if it considers these statements at all relevant, will consult the full statements rather than the snippets provided by the Gambia, and assess their meaning in the context of the ongoing terrorist attacks in October and November 2016 and August 2017. The court should thereby be guided neither by the Gambia's nor the FFM's interpretation of the statements, but should form its own opinion on whether these statements were actually made, by whom they were made, in what context they were made, and what they say. With these introductory remarks, Mr. President, let me move to the legal questions that the court is faced when examining the Gambia's argument on alleged hate speech and propaganda. The first question to be addressed is whether the Gambia's hate speech and propaganda argument is at all relevant for the establishing genocidal intent. Myanmar submits that it is not. The Gambia says the court must determine whether Myanmar's alleged use of hate speech and propaganda constitutes an indicator of genocidal intent. In its presentation last week, the Gambia referred 13 times to anti-Rohingya hate propaganda and the harmful utterances of Myanmar soldiers, speech acts it considers to be indicators of genocidal intent. It comes as no surprise that at the end of the presentation, the Gambia concluded that such hate speech and utterances are conclusive indicators of genocidal intent. The Gambia's argument, however, is based on its flawed indicators of genocidal intent approach. As I showed the court last week, the Gambia has asserted 7 so-called indicators of genocidal intent, and as you can see, hate speech and tolerance of hate speech are 2 of these indicators. This approach has no basis in the court's case law. The court follows an inference from a pattern of conduct approach. The court first establishes a pattern of conduct from which genocidal intent is then inferred. So there is no direct inference of genocidal intent from either hate speech itself or the tolerance of hate speech. The only question, therefore, is whether hate speech and the toleration of hate speech could be relevant for establishing a pattern of conduct from which genocidal intent could be inferred. Myanmar submits that alleged hate speech and propaganda have no role to play in the establishment of a pattern of conduct for the following reasons. First, a pattern of conduct has been defined as a consistent series of acts carried out over a specific period of time. The series of acts must be carried out immediately before, during, and after the attacks on the protected group. Many of the speech acts adduced by the Gambia do not meet that requirement for temporal reasons alone, some dating back as far as the 1980s. Second, the 2 elements of genocide, the actus reus and mens rea, must be linked. It is the acts committed by the perpetrators of the attack on the protected group that must form the pattern of conduct from which the mens rea is inferred. Extraneous factors, such as hate speech and toleration of hate speech, would inevitably raise the question of their relationship to the actual attacks and the question of causation. Third, in the Croatia case, Croatia suggested 17 factors which individually or taken together could indicate a pattern of conduct from which the only reasonable inference was an intent to destroy. These factors included The statements of public officials, including demonization of Croats and propaganda on the part of state-controlled media, and the use of ethnically derogatory language in the course of acts of killing, torture, and rape. Both Croatia and Serbia put forward arguments on alleged state-sponsored hate speech and propaganda in inciting genocide. Much of the argument made by the Gambia in the present case, including accusations of dehumanization, resembles the arguments made in the Croatia case. The only difference being that the alleged hate speech today is mainly made and disseminated online. In the Croatia case, the court did not use the two speech factors suggested by Croatia when establishing the existence of a pattern of conduct. As you can see on the screen, the court rather used factors that concern the scale and allegedly systematic nature of the attacks, the fact that those attacks are said to have caused casualties and damage far in excess of what was justified by military necessity, the specific targeting of members of the protected group, and the nature, extent, and the degree of the injuries caused to the targeted group. The Gambia's hate speech and propaganda argument is thus irrelevant for establishing an alleged pattern to destroy the Bengali Muslim group in whole or in part by way of inference from a pattern of conduct. If hate speech and propaganda were to be used in order to convincingly show an intent to destroy the Bengali Muslim group as such, by reference to particular circumstances, something the Gambia has not attempted to do, hate speech and propaganda would merely be circumstantial evidence. In order to convincingly prove genocidal intent with regard to a particular circumstance through circumstantial evidence, the Gambia would have to show that the speech acts are related to the particular circumstance in question and that the only reasonable inference from these acts was genocidal intent. Considering the other intents mentioned by the Gambia itself in its presentation, such as an intent to incite hatred or violence against the Bengali Muslims, or an intent to take revenge, an intent to destroy would not be the only reasonable inference from these speech acts. The Gambia's hate speech argument is thus irrelevant for establishing genocidal intent on the part of Myanmar with regard to the alleged commission of genocide. Mr. President, members of the court, even if the hate speech argument were relevant, the Gambia would have to prove in the first instance that the alleged speech acts are reflective of genocidal intent at all. The Gambia has not done so. Genocide is a highly contextual issue, and identifying genocidal intent requires careful assessment of the facts and their implications. The Gambia's case on genocide is advanced in the context of counter-terrorism operations, especially after the Arthur terrorist attacks in October and November 2016, and August 2017. This is essential context in which the Gambia's claim that certain statements are evidence of genocidal intent falls to be assessed. In these circumstances, the court is required to undertake a particularly careful assessment of the facts, including the Gambia's alleged evidence of genocidal intent. Let me say at the outset that the Gambia's approach to proving genocidal intent through statements is somewhat disingenuous. The Gambia focuses on snippets from statements, removed from their surrounding context, and integrated into the Gambia's own narrative of events. By presenting the statements in this way, the Gambia seeks to persuade the court that they are evidencing intent to genocidal violence during the anti-terrorist operations, or are more generally reflective of Myanmar's genocidal intent. None of this withstands scrutiny. The Gambia's attempt to insinuate an orchestrated top-down campaign of genocide led by Myanmar's senior general Min Aung Hlaing fails on the evidence. When read in their context and against the background of the counter-terrorism operations, the snippets from the Gambia's statements contain no espousal of genocidal intent, let alone a call for genocide or even simple violence. Let me give you two examples. Last week, the Gambia showed you an extract from a statement by the senior general in which particular emphasis was put on the following lines. The Bengali problem was a long-standing one which has become an unfinished job despite the efforts of the previous governments to solve it. The government in office is taking great care in solving the problem. These lines were taken out of context and presented as if the Bengalis were a problem and that the phrase "to resolve the unfinished job" served as a justification for the alleged government violence against the Bengalis. The Gambia does not provide any explanation for this distorted reading of the statement, other than to refer to a report by the FFM, which similarly gives no explanation. The speech was made 7 days after the major Arthur terrorist attack on the 25th August 2017, in which 29 people were killed, 8 bridges were destroyed by explosives, and some 2,700 houses from villages were burned down. However, rather than calling for violence against the Bengalis, the senior general said in the same statement, I quote, "There must be cooperative efforts to ensure that the people in Rakhine State have peaceful living conditions. The local people, for their part, need to return home and try to develop their region. There are many losses and tragedies in the aftermath of the incidents. Cooperation is necessary to remedy them as quickly as possible, while efforts must be made for regional development." Thus, rather than calling for violence against the Bengalis, the general was calling for cooperation. The second statement of the senior general, which the Gambia presented to you, was equally distorted. The statement presented reads, "The Bengali population exploded and the aliens tried to seize the land of local ethnics. Race cannot be swallowed by the ground, but only by other race. All must be loyal to the state in serving their duties, so that such cases will never happen again. Please note the ellipsis. The Gambia took two unrelated snippets from the same statement, which were 18 lines apart, in order to create the wrong impression that the senior general intimated that the Bengalis would swallow up the Rakhine race, and that the state was carrying out its duties to make sure that such violence from the Rohingya does not happen again. This is a gross misrepresentation. The relevant part of the statement read in full: area peace and stability and area control duties must be seriously carried out from the immigration point of view. In checking the cases in which Bengalis trying to sneak into the country through various means were seized, involvement of some officials were found. Race cannot be swallowed by the ground, but only by another race. All must be loyal to the state in serving their duties, so that such cases will never happen again. The 1982 citizenship law is not just for the Rakhine state crisis, it covers the whole country. The relevant part of the statement referred to illegal Bengali immigration into Rakhine state and the corruption by officials. The term such cases refer to cases in which Bengalis try to sneak into the country, not to the seizure of the land of local ethnics by Bengalis. The statement that all must be loyal to the state in serving their duties referred to the corrupt officials who were involved in Bengalis illegally entering the country. As the last sentence makes clear, the statements, including race cannot be swallowed by the ground but only by another race, was not especially directed at the Bengali Muslims in Rakhine state, but applied to the whole of Myanmar. There is no evidence of genocidal intent in these or other statements by the senior general. Even if viewed in isolation as a matter of their ordinary meaning, none of the statements selectively relied on by the Gambia calls for the physical destruction of the group of the Bengali Muslims in whole or in part as such. Mr. President, once the statements of Senior General Min Aung Hlaing fall away, all that is left are alleged statements by a small number of low-ranking soldiers, regional party leaders, fringe politicians, Buddhist monks, and posts on Facebook pages that were allegedly connected to the Myanmar military. None of these statements qualifies as direct and public incitement to genocide, or is reflective of a genocidal intent of its author. The Gambia tries to gloss over this deficiency by referring instead to hate speech and anti-group propaganda as an indicator of Myanmar's alleged genocidal intent. I have already pointed out the flaws of the indicator of genocidal intent approach. There is, however, also another flaw in the Gambia's argument. There is a difference between hate speech in general, or inciting discrimination or violence, and incitement to commit genocide. Incitement to commit genocide requires more than incitement to hatred or violence. It requires genocidal intent on the part of the instigator. The Gambia has not proven any genocidal intent on the part of the authors of the alleged hate speech acts. Hate speech on its own, however defined, cannot establish genocidal intent. And I may add, the same is true for erroneous opinions or deliberate misrepresentations of historical events. While some of the statements presented by the Gambia may have expressed hatred or even incited violence, they did not call for the destruction of the Bengali Muslims as a group, either in whole or in part, as such. One post presented by the Gambia last week as part of a several-year-long anti-Rohingya hate propaganda campaign entitled "Why Hitler Killed the Jews" was not even counted as hate speech against Rohingya by the IIMM, as neither Rohingya nor Muslims were mentioned in the post. Thus, even if the hate speech argument was relevant for establishing genocidal intent on the part of Myanmar, which it is not, the Gambia would have to prove by conclusive evidence that the authors of the hate speech acts themselves had genocidal intent. It has not done so. Mr. President, members of the court, let me move on to my next point. Even if the Gambia could prove that some of the alleged hate speech acts were reflective of a genocidal intent, it would still have to show that these acts are attributable to Myanmar. In the Bosnia and Croatia cases, the court required fully conclusive evidence in order to prove attribution of facts. Acts of a state's military are generally attributable to the state. However, this does not absolve the Gambia from proving that the speech acts themselves are attributable to the military. In its presentation last week, the Gambia attributed a number of Facebook posts to the Myanmar military, the Tatmadaw, saying, "The Tatmadaw posted, the Tatmadaw disseminated, the Tatmadaw shared." It also concluded all of these messages came directly from the Tatmadaw. However, this is not proven by fully conclusive evidence. The Gambia simply treats all pages on Facebook that were identified on the basis of some technical indicators as being associated with the Myanmar military as forming part of a network that was connected to the Myanmar military. Consequently, it treats all posts appearing on these pages as posts by the Tatmadaw. Myanmar does not accept that there was such a connection. But more importantly, being connected to or associated with does not meet the requirements of attribution under international law. Even if it could be proven that statements were posted or shared by the Tatmadaw on Facebook, this does not automatically demonstrate genocidal intent on the part of Myanmar. As the court found in the Croatia case, atrocities committed over many communities over a lengthy period focused on Bosnian Muslims could not demonstrate genocidal intent. What was required was to show that the acts were part of an overall general plan. the Gambia would have to demonstrate that these posts were part of a premeditated, concerted plan to destroy the Bengali Muslims in whole or in part as such. This the Gambia has not and could not do, as no such plan existed. Similarly, there is no legal basis to attribute statements by a regional political party, leaders of a fringe nationalistic opposition party, or Buddhist monks to the state of Myanmar. Even if such statements by individuals, including individual soldiers, were attributable to the state, that would not, as of itself, establish genocidal intent on the part of the state. For a state to be held responsible for genocide, the state itself must have the intent to destroy a protected group in whole or in part as such. This cannot be established simply by attributing to the state the genocidal intent of one or more individuals. As the court held in the Croatia case, the genocidal intent of a state is to be sought in the state's policy or is to be established indirectly by inference from a pattern of conduct. It is not to be established by way of attributing the genocidal intent of individuals to the state. Mr. President, let me conclude. The Gambia's hate speech argument is irrelevant for establishing genocidal intent on the part of Myanmar, because genocidal intent is not established on the basis of hate speech and toleration of hate speech as factors indicating genocidal intent, but through inference from a pattern of conduct. Both hate speech and its toleration do not form part of the factors establishing the relevant pattern of conduct. Even if the statements which the Gambia refers to as anti-Rohingya hate speech and propaganda were relevant for establishing genocidal intent, the Gambia would still have to prove by conclusive evidence that these speech acts are reflective of genocidal intent on the part of their author. It has not done so. Even if some of the statements were reflective of genocidal intent, quod non, the Gambia would have to prove by conclusive evidence that the speech acts in question are attributable to Myanmar. Again, the Gambia has failed to do so. Even if some statements by individuals reflecting genocidal intent could be attributed to Myanmar, the state's genocidal intent cannot be established by way of attributing to the state the genocidal intent of one or more individuals. Accordingly, the Gambia's submissions on hate speech are so far removed from and fall so short of proving genocidal intent that they cannot be sustained. This concludes my presentation. Mr. President, members of the Court, I thank you for your careful attention. May I now please invite you, Mr. President, to call on Professor Miron.
I thank Professor Talmon for his statement. J'invite maintenant la professeure Alina Miron à s'adresser.
I now invite Professor Alina Miron to address the Court. You have the floor, Madam.
Monsieur le Président, Mesdames et Messieurs les...
Mr. President, members of the court, good morning. I now have the duty to dispel the allegations relating to the obligation to punish the genocide. My arguments will roughly cover those that Myanmar has put forward under Chapter 12 of its written submissions. In sum, the Gambia considers that Myanmar has failed to comply with its obligation to punish the genocide because, or so it says, it failed to conduct any serious investigation nor to prosecute on the basis of the facts submitted to the court. And moreover, because Myanmar is alleged to have concealed or destroyed evidence related to these events. According to Gambia, these are or would be indicators of an genocidal intent. And it would also be an autonomous count of responsibility for violation of the convention. I think we can dispel and do away with the first function pretty swiftly. And we should do so at the outset to avoid having fanciful arguments in our discussions. The Gambia does not, indeed, show how a lack of serious investigation and concealment of evidence, were they to be established, quod non, how all this could contribute in and of themselves to the destruction of the protected group, even though they are not part of Actus Reus. Gambia does not either show how such facts would, retrospectively, help shed light on the specific intent to destroy a protected group, which is said to have driven the defending state at critical times. By way of demonstration, our colleagues across the aisle rely on sweeping arguments. Ms. Alamin, for instance, states, and I quote, "The destruction and the concealment of evidence thus betrays the genocidal intent of Myanmar. This destruction builds upon and consolidates the genocide," end quote. Professor D'Argent, on his part, puts forward a circular reasoning, and he says, "Impunity points to a doilish specialis. That is a common sense proposal that the UN fact-finding mission took up as the seventh and final indicator of genocidal intent," end quote. Yet, this construction has not been validated by any international jurisprudence, not even by the jurisprudence relied upon by Gambia. In oral arguments, this jurisprudence, in fact, dwindled away. In its written submissions, the Gambia relied on the Akayesu and Karemera judgments of ICTR, which in fact did not relate to obligation to punish, but in fact to the command responsibility. In oral arguments, there was only one vague reference to the Kastich judgment handed down by ICTY, lost in a footnote. And that judgment is also irrelevant. The ICTY did not relate or reviews destruction of evidence, but it was in fact dealing with the mutilation and removal of bodies, which in that specific case had contributed to proving genocidal and intent on the part of General Kastich during the assault on Srebrenica. Myanmar discussed this jurisprudence in its counter-memorial, but Gambia made no attempt to address and respond this in its reply, and in oral arguments it gave no further justification to help base this legal construction on law. The relationship between, on the one hand, the alleged failure to punish and the destruction of evidence, and on the other, the establishment of dolus specialis, is therefore not established. Far from being a compelling evidence of its genocidal intent or a common sense proposal, the failure to punish and destruction of evidence have no relevance as concerns dolus specialis. Which brings me to the second function that the Gambia gives these allegations. That they support the violation of other material obligations under the conventions, more specifically the obligation to punish and Articles 1, 4, 5 and 6 of the convention, which you will find under tab 0 of your bundle. The submissions of the Gambia include these counts of responsibility. This being said, and as your court found in the Genocide in Croatia case, the obligation to punish can only be breached if acts of genocide have indeed been committed. The Gambia recognizes this expressly in its written submissions, even though with some confusion. In paragraph 9.101 of its reply, you can read the following. Finding that Myanmar failed to punish genocide is independent from any finding of responsibility under Article 3, and it does not require the court to find dolus specialis on its part. The only requirement needed to find that Myanmar failed to punish genocide in violation of Articles 1 and 4 is that acts of genocide occurred, irrespective of whether these acts are attributable to Myanmar or not. As this is unquestionably the case, the court should determine that Myanmar's state-sanctioned impunity for members of the Tatmadaw, in addition to constituting a clear indicator of Myanmar's genocidal intent, are indeed a breach of Articles 1 and 4 of the Convention. In other words, under this count of responsibility, the Gambia invites the court to determine and find that their genocidal acts were committed by members of the Tatmadaw without, however, finding that they are attributed to Myanmar and without establishing the dolus specialis of the state itself or of these specific individuals. The Gambia suggests that the simple occurrence of material acts under Article 2 could trigger the obligation to punish without the perpetrators being driven by genocidal intent. Were that to be the meaning to be given to that somewhat convoluted reasoning, can I state that, or recall that Article 4 of the Convention requires that those committing genocides or other additional acts of under Article 3 be punished, and I'll come back to that this afternoon. And this requires prior establishment of actus reus and dolus specialis on the count of those accused of such acts. However, the Gambia does not explain how the court may go along with this approach, even though it has no jurisdiction on individual criminal responsibility, and the Gambia itself attributes these acts to members of the armed and police forces of Myanmar. This really contains much contradiction. In any case, should the mention of the obligation to punish ultimately aim at avoiding the proving of dolus specialis or the potential attribution of some acts to Myanmar, then it will necessarily fail. Indeed, the Gambia has given no proof of the fact that genocidal acts were indeed committed, and it cannot avoid doing so by establishing an additional responsibility for failure to punish. Our colleagues across the bar have realized the bind therein. Indeed, in oral proceedings, they state that the Gambia obviously goes along with the court's jurisprudence, and that the obligation to punish the genocide cannot be breached in the absence of genocide. Such support is, however, partial, seeing as, contrary to what Professor Dajan mentioned, he says, Ms. Jones says,
arises as soon as there are reasonable grounds to believe that genocidal acts have been committed. Fin de citation. Les deux...
These two propositions are not compatible, and we are eager to hear what Gambia's actual position is in this respect. The Gambia was not able to discharge its duty to show that genocide had been committed. Therefore, there is no need to discuss the allegations relating to impunity and to the destruction of evidence. It is therefore, for the sake of completeness, that I will show that Myanmar did not fail to comply with its obligation to punish the genocide under the Convention. Let me look first of all at the nature and scope of application of the obligation to punish genocide. Then I will show that not only do these allegations of destruction of evidence lack relevance, but they are also not established. And lastly, we shouldn't really dwell on the allegations relating to the lack of cooperation with organs of the United Nations, because they lack relevance in this case, but I shall discuss them briefly at the end of my presentation. Mr. President, both parties manifestly disagree on the scope itself of the obligation to punish. In fact, the Gambia generally avoids this question and puts forward an absolute conception of the obligation to punish. Yet nothing in the Convention supports this position. The obligation to punish and the obligation to prevent is an obligation of conduct, not an obligation of result, contrary to what Gambia states. The parties to the Convention have the obligation to use all appropriate means at their disposal to punish the persons responsible for the genocide. An obligation of result aims at achieving a specific outcome, in this case, the punishment of the perpetrators of a genocide. Were we to be faced with an obligation of result, it would be breached if the result reached were different from the one that the state was to ensure. Namely, the individual authors of the genocide would have to be identified, arrested, tried, sentenced, and the sentence carried out for the result to be reached. Yet, at every one of these steps, specific and particular circumstances may lead to adjust the scope of the obligation weighing on the state. And the responsibility of the contracting party would only be involved if it had manifestly not made use of the means it had at its disposal to do so. So it is indeed an obligation of conduct. Moreover, the nature of the obligation to punish is a very theoretical debate which has no practical consequences and purchase in this case, for indeed Gambia has not shown that a genocide has been committed, nor has it identified the perpetrators against whom Myanmar should exercise said obligation to punish. The fact is that the obligation to punish can only be held up against a party if the facts are likely to come within the scope of application of the Convention. This is a requirement linked to the field of application ratione materia of the Convention as a whole. Yet the Gambia tends to refer to a failure to punish the crimes and atrocities against the Rohingya, that's what I'm quoting them, of course, in a general way, or more specifically, failure to punish war crimes committed during the 2016 and 2017 anti-terrorist operations. Yet it is obvious that these do not come under the obligation to punish under the Convention, the Genocide Convention. Leaving some crimes unpunished does not mean that they constitute genocide. As I have said, to be able to say Myanmar has an obligation to punish, the Gambia must show that it is likely a genocide was committed. And this requires at the very least, two sets of accurate statements. First of all, accuracy relating to the specific facts and their geographical location. And secondly, accuracy as concerns the persons alleged to have committed the alleged acts of genocide. These basic details are required to establish whether the facts and behaviors at hand are likely to come under the Convention. However, as my colleagues have shown, the allegations of the Gambia are particularly lacking in accuracy. On facts, it is remarkable, for instance, that the Gambia should insist on the violation of an obligation to investigate alleged genocidal acts during the 2016 operations. You may recall the first wave of impunity, as mentioned by Professor Dargent. And this, even though the Gambia doesn't really detail these facts in its written submissions or in its oral submissions. And that is what my colleague Lee Laurie mentioned extensively yesterday. As concerns the identification of the authors, when you look at the titles of the chapters in its written submissions and over the course of the pleadings, the Gambia generally refers to the Tatmadaws impunity as a state institution, whereas the obligation to punish relates to specifically identified individuals. Insofar as the Tatmadaw as a whole is covered by these allegations, they cannot come under the obligation to punish under the Convention. And the same goes for the repeated allegations on relating to the judicial system in Myanmar as a whole. Admittedly, at some points, the Gambia did try to identify individuals whose acts may trigger the obligation to punish. To that end, it uses the list of 6 army commanders established by the FFM. Yet it seems to be using these cases in an indicative manner only, and its final submissions, the Gambia is not asking the court to declare a violation of an obligation to punish specifically related to these individuals. The FFM and the Gambia focus not on the alleged perpetrators, but on those exercising effective control over them. The 6 military commanders thus identified were identified on the basis of the command responsibility. Yet the Gambia has not shown that the obligation to punish applies to these military commanders under the 1948 Convention.
En effet, la responsabilité.
Indeed, the criminal responsibility of the superior is a principle according to which that person, individually, is criminally responsible for the crimes committed by his subordinate if he knew or should have known that they were committing or were likely to commit such acts, and that the commander did not take the necessary preventative or punishing measures. But the Gambia does not show that Articles 4 and 6 of the Convention, which refer to, and I quote, persons committing genocide or any other of the acts enumerated in Article 3, end quote, it is not shown that those articles require that a superior be criminally responsible for the acts of a subordinate. The very wording of these provisions, I have quoted, do not require a contracting party to punish a military commander who did not commit the acts enumerated in Article 3 for the simple reason that he did not punish those who did commit them. Now, of course, command responsibility is enshrined in the statutes of International Criminal Courts and the ICC. Within these responsibility regimes, it therefore applies according to the carefully chosen wording of their specific provisions, which are not found in the Genocide Convention. This is yet another example of the differences between, on the one hand, the way in which individual responsibility for genocide is provided for in international criminal legal texts, and on the other hand, the way in which one may view the responsibility of states under the Convention. On this point as well, the Gambia eludes the debate because in its reply it simply makes the following sweeping statement, and I quote, "Command responsibility for senior officials is a form of state responsibility that falls under the Convention," end quote. That falls within Article 9 of the Convention. No reference or demonstrations follows. Thus, the Gambia has not demonstrated that the facts that it considers as amounting to a failure to punish might come under the scope of the Convention. Members of the Court, I will, however, once again for the sake of completeness, look into the allegations concerning a serious failure to investigate.
Convention ne contient qu'une.
The Convention only contains a general reference in Articles 1 and 4 on the obligation to punish, but provides no specific obligation to investigate or prosecute. Thus, Article 6 provides that, and I quote, "Persons charged with genocide or any other of the acts enumerated in Article 3 shall be tried by a competent tribunal of the state in the territory of which the act was committed," end quote. This provision does not contain references to inquiries, or rather investigations, and prosecution. That being said, Myanmar agrees that investigations and prosecution are logical precursors to holding a trial and issuing a sentence, and thus could be included in the general obligation to punish. It remains, however, that the scope of the obligation to investigate and that of the obligation to prosecute are not laid down in the Convention. But these two obligations could not be triggered without precise identification of those individuals suspected of the crime of genocide or one of the acts in Article 3. The obligation to prosecute or extradite case raised in the hearings by the Gambia confirms this interpretation. In the present case, by speaking to the obligation to carry out a preliminary investigation that appears in Article 6, Paragraph 2 of the Convention Against Torture, the Court considered that the state must comply with it, and I quote the Court, "as soon as the suspect is identified in the territory of the state," end quote. The triggering of the obligation to investigate thus imposes, at the very least, an obligation, or rather an obligation to identify, at the very least, those suspected of the crime in question. Regarding the conditions in which such an obligation is triggered, one can only see that the 1948 Convention says nothing on the matter. This is a major difference between the case concerning the application of the International Convention for the Suppression of the Financing of Terrorism, Ukraine versus Russia. In the 31st of January 2024 judgment, the Court examined two connected obligations in the light of the specific provisions of the Convention for the Suppression of the Financing of Terrorism, that is to say, Article 9, first paragraph, for the obligation to investigate, and the first paragraph of Article 10 for the obligation to prosecute. Thus, concerning the obligation to investigate, it is because of the specific terms of these provisions that the Court has ruled, and I quote, that the evidentiary threshold for the obligation to investigate is relatively low. Article 9, paragraph 1, requires only that a state party receive information that a person who has committed or who is alleged to have committed the offence of terrorism financing may be present in its territory. The facts provided may be general in nature. End quote. But even in a situation such as this, where treaty law is quite clearly not particularly demanding, the court did require that credible information had been made known to the requested state. The court insisted that there was no obligation to investigate if nothing supported the allegations of violation of the Convention on the Financing of Terrorism, or that these allegations were not sufficiently detailed or individualized. As Myanmar underlined in its written submissions, there can be no obligation to investigate if there is no credible information leading one to believe that a genocide has been committed. This therefore implies that there is the beginnings of proof of the actus reus and the dolus specialis, of which Myanmar has been specifically informed. No matter what the Gambia said or the intervening parties that have spoken on this matter, the threshold of the reasonable grounds to believe that genocide has been committed is not too high. In the obligation to prosecute or extradite case, the court decided that Senegal was obligated to initiate preliminary investigations to establish a fact from the moment where complaints had been made before its authorities, and that these authorities, and I quote the court, had reason to suspect Mr. Abre, who was in their territory, of being responsible for acts of torture, end quote. In the present case, there is no identification of presumed perpetrators, as I've said, nor complaints of victims, nor are there other reasons to suspect individuals in particular of having committed genocide. The FFM report does not meet the expected requirements to trigger an obligation to investigate. As I have just said, it focuses on a presumption of command responsibility, which does not amount to one of the forms of responsibility for genocide under the 1948 Convention. In the same way, and as opposed to what the Gambia alleges, the inclusion of the 6 commanders on the list of sanctions adopted by some Western state is not reasonable grounds to launch an investigation. These are simply administrative measures adopted by third parties without a serious examination of the facts. Finally, the university clinic studies that the Gambia is relying on, for lack of a better alternative probably, cannot constitute reliable indicators that there is an obligation to investigate. The Gambia cannot do away with its obligation in terms of the burden of proof by passing it on to Myanmar. It is, however, what it is once again attempting to do when it states that it is for Myanmar to demonstrate that it investigated, condemned, and punished the perpetrators of the crimes committed against the Rohingya. End quote. The Gambia has therefore not met the applicable standard of proof, because it has not established that the Myanmar authorities had sufficiently plausible information leading it to believe that military staff involved in the operations was moved by a genocidal intent. The obligation to punish provided for by the Convention therefore does not apply. Finally, and ex abundant cautela, I underline that Myanmar did launch inquiries into the facts concerned by the present proceedings. In general, it is required to undertake a meaningful investigation into the alleged facts in accordance with the laws and procedures that the state would ordinarily follow when presented with information on the commission of a serious crime. That is the Ukraine versus Russia 2024 ruling, or judgment rather. And as in many other countries, the justice system in Myanmar is of dual nature. If the presumed perpetrators are civilians, the authorities in charge of investigations and prosecution are the national police and the general public prosecutor. If the presumed perpetrators are members of the Myanmar Armed Forces, it is the military justice system which has jurisdiction. The Gambia is calling this system into question as a whole. That being, the obligation to punish does not force a state to reform its justice system. That obligation can therefore not be raised by the Gambia to require that investigations and prosecution take place in a setting that would depart from the existing constitutional framework. The organization of judicial services and the attribution of competence to different bodies are a matter of constitutional autonomy of states. And the many arguments of the Gambia aiming at requesting or requiring reforms to the existing framework based on the obligation to punish are therefore void. Furthermore, Myanmar set up several complementary mechanisms whose mission was to shed light on allegations of crimes in Rakhine State in 2016 and 2017. Firstly, you have the Mangdo Investigation Commission, created in 2016, and whose final report was published on the 8th of August 2017. Following its investigation, this commission concluded that there was no proof of genocidal intent. It noted inter alia that some cases of human rights violations and torture supported by evidence had been investigated. Some gave rise to judicial prosecution. Concerning the disproportionate use of armed force, this report concluded that if those facts were true, those concerned should be treated as in accordance with the law. The second mechanism is the Independent Commission of Inquiry, created in July 2018. It was tasked with investigation allegations of human rights violations and connected questions linked to the events of 2016 and 2017. This commission was made up of 2 Myanmar nationals and 2 international experts. It published its report on the 20th of January 2020. The Gambia is calling into question the independence of this commission without providing proof of its accusations. It is distorting, what's more, the conclusions that this commission reached. And I would refer you to the written pleadings of Myanmar, which counter in detail Gambia's allegations. Finally, following the Independent Commission of Inquiry's final report, the President of Myanmar set up a body in charge of investigations and criminal prosecution against civilians and possibly police officers suspected of having committed crimes during the 2016 and 2017 events. This body is made up of the representatives of the police and the Office of the Attorney General. Myanmar's different reports on the implementation of provisional measures show the activities of this body, which were singularly hindered by the security situation in Rakhine State. Gambia's objection on this matter bear on the body's lack of jurisdiction concerning members of the military. These also do not hold for the same reasons that I have laid out. The obligation to investigate must take place within the existing procedural and constitutional order. I now come to the obligation to prosecute and to try. As before, I believe it is important to begin by clarifying the nature and the extent of this obligation before I respond to the Gambia's allegations, according to which the prosecution carried out by Myanmar was not serious. From the outset, I would specify that these prosecutions were not started for acts of genocide because there was no proof supporting such an accusation. These discussion of a factual matter are therefore for the sake of completeness. As the courts specified in the arrest warrant and Ukraine against Russia 2024 cases, even the specific clauses of audedere audjudicare do not give rise to an absolute obligation to prosecute. The competent authorities of the state parties to the ICSFT retain the responsibility to determine whether prosecution is warranted, based on the available evidence and applicable legal rules." End quote. In these two judgments, the court insisted on the discretion that is afforded the seized state. Thus, the obligation to prosecute was formulated in such a way as to leave it to the competent national authorities to decide whether or not to initiate proceedings, thus respecting the independence of states' parties' judicial systems. It follows that the competent authorities involved remain responsible for deciding on whether to initiate a prosecution in the light of the evidence before them and the relevant rules of criminal procedure." End quote. What's more, the standard of proof required to prosecute is necessarily higher than that to trigger investigations. What's more, it reflects the gravity of the accusation. Thus, concerning the financing of terrorism, the 2024 judgment insists on the fact that the decision to submit a case to the competent authorities for purposes of prosecution is a serious one that requires, at a minimum, reasonable grounds to suspect that an offence has been committed.
Fin de citation.
End quote.
Gambia fully ignores this discretionary power given to national authorities. It attempts to substitute for it discretion given to the fact-finding missions, even opinions coming from NGOs, journalists, or academics. As my colleagues have shown throughout their oral arguments, the evidence relied upon Gambia are far from constituting overwhelming evidence of genocidal acts. This as stated by Gambia. And it's once again by denying the discretionary power of the state that Gambia can state the failure to prosecute constitutes in and of itself evidence that there is a breach of the duty to punish, whereas, in fact, it is part of exercising the power to assess the evidence and characterize the facts by the incriminated state. Gambia commits another error in its analysis when it states that the prosecution must be based on special legislation on genocide. I will be returning to this point this afternoon when I review the alleged obligation to adopt special legislation. At this juncture, I would like to point out that the court has explicitly recognized in its judgment in Ukraine versus Russia that an obligation to prosecute is exercised within the confines of existing legislation. Therefore, the contracting parties can rely on the general provisions of their criminal law, particularly those that address crimes such as murder, bodily harm, and rape. Furthermore, regarding the provisions on criminal procedure. Therefore, the Gambia's arguments are inoperative, whereby prosecution before military courts are, by their very nature, inadequate because they are not under civilian control. So such an argument is inoperative. Thus, it is the public body that is charged with the investigation to determine whether sufficient evidence against an individual to justify initiating proceedings against said person. Unlike what Gambia is claiming, it is not up to the fact-finding mission to decide whether Myanmar should investigate certain individuals or prosecute them. Furthermore, the court cannot itself determine whether there are reasonable grounds to believe that named individuals should be prosecuted for acts of genocide. Finally, as has already been abundantly demonstrated, Myanmar has initiated proceedings against certain members of its armed forces for facts that were committed during the anti-terrorist operations, and some of these individuals were sentenced to prison terms. Gambia recognizes this while minimizing these examples as it deems that the sentences were too lenient. The work of the body responsible for criminal investigation prosecution that I mentioned led to the indictment, in some cases to the conviction of civilians involved in crimes that were committed in 2016 and 2017, some of them being members of ARSA or Rakhine civilians or law enforcement agents. Several reasons explain why there are impediments to the work of this body. The lack of evidence and formal charges, as well as the security situation in the Rakhine state, has made any further work difficult, and this explains why other prosecutions have not been initiated since then. Mr. President, let me now address the allegations that evidence has been destroyed, destruction that would have taken place in order to prevent the initiation of a prosecution for genocide. According to Gambia, these acts amount to not only dolo specialis, but also a breach of the obligation to punish. Last week, Gambia's council turned a public report of the fact-finding mission, the central part of their demonstration on this point. This report is not part of the case file, and the court had refused to accept this document unless it was introduced by the Gambia, considered that it was readily accessible using a provision of the rules, this against an explicit decision of the court. In its wisdom, the court allowed Gambia to continue in this manner. I note, however, that Gambia itself interpreted this, the initial decision of the court, as being based on the fact that the report was not necessary for the discussion. Myanmar, just like the court, considers that this report is not necessary for deliberations, so I shall not dwell upon it in my presentation this morning. I shall begin by looking at the allegations of the destruction of evidence that were made by Gambia last week. I would like to start with the macabre evocation of numerous mass graves and the sordid accusations that corpses were mutilated by being burned or destroyed with acid. What evidence has Gambia provided regarding mutilation? Nothing more than an article coming from the Associated Press, which is being honorifically qualified of public report, and that appears under one of the tabs in your folder. Associated Press claims that it examined videos on cell phones with timestamps, satellite imagery, and that it conducted interviews. Gambia trusts all of the above without question. Did it even try to trace the underlying evidence which are not in the case file? Most likely they did not. Now, let me address the allegations on the burned bodies and the mass graves. Myanmar does not contest that they may exist. Far from that. Provided, of course, that one bears in mind the local and factual background. Indeed, it does not suffice, as Gambia's council attempts to do, to simply invoke in the abstract the rules of international humanitarian law to conclude without further proof that there has been deliberate destruction of evidence and that there is evidence of the existence of genocidal intent. It is not challenged that the operations did lead to casualties amongst the Bengali population. However, it is necessary to distinguish civilian casualties and casualties amongst the ARSA forces in relation to hostilities. Mr. Blomcooper and Ms. Laurie have examined this aspect yesterday. Furthermore, the quick burial of bodies, including in mass graves, is not at all anomalous in a country and at a season when the average temperature is close to 30 degrees Celsius. Failing to bury bodies can lead to water sources being contaminated. As for the incineration of bodies, this is a widespread practice, even if it is not necessarily in accordance with Muslim rites. Such practices may clearly be shocking in peacetime, given the concept that we have of the respect that is owed to the dead. But they may not be assessed according to the same criteria in times of fighting and without bearing in mind the local context. This is especially so because burial in mass graves was not only carried out by armed forces or law enforcement agents. Bengali villagers also use such practices if we are to give credence to the fact-finding mission's 2018 report. Gambia is clearly attempting to conceal this information, given that page 188 of the report, where this is mentioned, was removed from Annex 40, appended to its memorial, whereas pages 187 and 189, the preceding and following pages, are both in the annex. Finally, the allegations that there was widespread destruction of Rohingya villages by fire by bulldozers. Gambia deems that this is evidence of dolus specialis for two reasons. First of all, as an indication of genocide and as a practice to destroy evidence to hide the crime. The account by Gambia presents the same lack of evidentiary value as the rest of its arguments. My colleagues have sufficiently repeated this, and I can be succinct. This account raises numerous questions. In what way can these facts constitute evidence of genocide? As such, they come neither under actus reus nor under dolus specialis. Gambis does not even discuss this. Whereas it states that the destruction of villages was widespread during the 2016-2017 operations, in the presentation of this evidence, as unsatisfactory as they may be, Gambia makes no distinction between the locations where military operations were conducted and those where there were no such operations. Thus, Project Otseli, that it refers to both in its written submissions and in its oral arguments, contains evidence related to locations where there was no fighting. What crimes could have been hidden in locations where no genocidal acts were alleged to have taken place? Gambia mixes up the allegations that relate to facts that took place during the anti-terrorist operations of 2016-2017 and those that relate to subsequent facts. Myanmar accepts that there were destruction of dwellings during the anti-terrorist operations, but these were aimed at legitimate military objectives. Other instances of destructions were actually perpetrated by ARSA, and they took place either in Rakhine villages or in Bengali villages, where ARSA members deliberately burned some houses. Other houses were destroyed during confrontations with Myanmar's armed forces. Unlike what is being claimed by Gambia, this destruction is anything but widespread. Mr. Blom-Cooper will be returning to this point in detail later on today. Let me just recall that despite the tendency to extend the geographic scope of events as seen with the allegations, hundreds of Muslim Bengali villages in the northern Rakhine state were not affected. The last point that I want to address regarding the allegations of destruction of evidence has to do with effects that took place subsequent to the anti-terrorist operations. Gambia puts great emphasis on the alleged burning in the Boichidong township in May 2020, where Bengalis lived before 2017. These allegations are also relevant as regards the implementation of the Order on Provisional Measures. And in this regard, it should be examined. And the second report submitted by Myanmar refutes this. Without going over all the detailed in these allegations, I would like to stress how little care Gambia has brought to evidentiary matters. Its allegations are entirely based on an oral report by the High Commissioner for Human Rights of the UN. As explained in the second report, Myanmar conducted verifications with satellite imagery and NASA's fire detection data for all of the Butitong Township during the period from December 2019 to July 2020. This data showed no visible sign that villages were burned during the period under consideration. Yet, Gambia persists in claiming that the hastily drawn findings of the High Commissioner were necessarily corrected, although they were anonymous, summarily rejecting any exculpatory evidence just because it originates with Myanmar. Mr. President, finally, I would like to address the allegations related to the failure to cooperate, and I think I have 3 or 4 minutes to go, if you will allow me, before the coffee break. So once again, Myanmar's failure to cooperate with some UN bodies, in particular the mission, the mechanism, and the special rapporteur on the human rights situation. Both sides agree that the Convention on Genocide contains no obligation of cooperation with non-jurisdictional bodies. This is a clear distinction between this case and the case involving genocide in Bosnia, case in which the court found that Serbia had failed to meet its obligation to cooperate with the International Tribunal for the former Yugoslavia, which is implicitly included in Article 6 of the Convention. Furthermore, this court, in its order, rejected the provisional measure sought by Gambia, requiring that Myanmar would give access to and assist the fact-finding bodies of the UN. Aware that there's no treaty obligation to cooperate with these bodies, Gambia then took a different tack in its reply and during this hearing, and chooses to see here evidence of Tatmadaw impunity. This is a new example of the circular reasoning that flaws all of its arguments. It posits as a premise that which it must demonstrate, that is, that a genocide was committed by Tatmadaw and the failure to punish. But barring any evidence, direct or indirect, Gambia indulges in speculation with no real logic. It explains that it refused to recognize the mandate of both bodies, the mission and the mechanism, was motivated by the doubts it had about its impartiality. It should come as no surprise that Gambia pays no credence to Myanmar's concerns regarding the methodology used by these bodies. My colleagues have shown just how deficient they are, so I will not dwell upon this. I would like to, however, stress one point. Myanmar has the right to challenge them and has the right to challenge their findings. Without this, in and of itself, constitutes evidence of dolus specialis or a breach of the obligation to punish. Mr. President, I have finished with my presentation this morning. I would like to thank the court for its kind attention, and I would like to now give the floor to Mr. Samblum Cooper, probably after a coffee break.
Merci.
I would like to thank Professor Myron.
The next speaker, the court will observe a break of 15 minutes. The sitting is suspended.